So we were going to give the lawyers an opportunity to do the closing arguments, and then just a quick discussion about what you think the court should do, and then we'll start the CRAs. Laura, you're the attorney for the children. Why don't you go first?
Okay. Did I just go right into it? As we all know, it's a constitutional right to raise our children. However, this right is not guaranteed and it is not absolute. To take away the raising of our children, there are two requirements. One is that there's clear and convincing evidence of parental unfitness and that it's also in the best interest of the child. Never is the clear and convincing evidence standard replaced by preventative evidence, which has been discussed during this hearing. This hearing has been a comparison between the biological mother and the foster mother and a set of double standards. We think that there are concerns with the daycare at Crittenden House for Sissy. However, we do not have any concerns that Mrs. Jackson is going to put these same children into daycare. We're concerned about Sissy being raised in an abusive, neglected home. However, there's no concerns that Mrs. Jackson has raised an abusive son who we don't even know where he is, and he is not attending school, nor is he working. And finally, we know that Sissy has the loving home of her grandmother available, but we contrast that to Mrs. Jackson's home. We have no idea what kind of exposure these children will have to their abusive father when and if he comes to the home. The focus of this hearing is supposed to be on the fitness of Sissy Harrison. And again, it's the clear and convincing evidence that she is fit or not fit that we should be focusing on, not double standards and not comparison with the foster mother. Thirdly, we have a young woman. She essentially raised, nurtured, and loved her two younger siblings. She has proven to everyone that she was deeply attached to these girls. She's been shown that she can be motivated by her attendance at school and seeking out her parenting education when she's in the right environment. She has a very strong and loving grandmother who will provide love and assistance to her and the two girls. And finally, and last but not least, we have this service plan. The service plan provides education, job training, housing, daycare, parenting training, therapy, counseling, health care, and nutritional information. Let's not misinterpret it that this service plan means that Sissy is unfit. She is not unfit. This service plan is merely to fortify her for the challenge of motherhood and raising two young twins. Thank you.
Thank you. Attorney for Sissy.
Sissy was a victim of terrible upbringing, circumstances of a terrible upbringing. She was a victim of these circumstances, and this court shouldn't judge her on things that were out of her control. The clear and convincing standard was not met here. She showed love and affection and loyalty towards her two sisters and grandmother throughout this whole ordeal, being displaced in 7 different homes throughout the years. Her truancy, though it's not excusable, if looked at by the facts, one might understand that her level of insecurity is far beyond what anyone should have experienced in life in general. So her unwillingness to attend school should be considered as far as her situation goes. However, she did show a willingness to want to mother her children, her two kids, and despite all the abandonment and neglect that she experienced, she still has hope and love in her heart to raise her kids. She has a plan lined up with the Crittenden House to get her started, although it's temporary and not ideal. A lot of other children in this country have it a lot worse. So, with that said, this court should definitely grant Sissy her kids back and give her a chance to raise her. She hasn't lived the most comfortable life, and there's no reason for this court to make it worse for her.
Thank you. And finally, the petitioner.
Good afternoon, Your Honor. You have heard testimony about 3 kids in trouble. 2 twin girls, Carol and Sandy, who were only a year old, and their mother, Sissy, who was only approaching 17. The department does not dispute that Ms. Harrison has lived a very traumatic childhood, witnessing so much domestic violence, substance abuse, and the frequent shifting from one foster home to another. In fact, it is for many of these reasons that the department is so concerned about these 3 girls. Raising a child is a difficult responsibility. Raising twins is even more challenging. Couple that with the fact that Ms. Harrison is also a child, and the situation reaches near impossibility. When you factor in the childhood experience of Ms. Harrison with her lack of maturity, her inconsistent past of following plans for improvement, her lack of a support system, her mental instability, and her lack of education, you get a dangerous situation for Carol and Sandy. You have seen Ms. Pastis' report and plan for the success and healthy development of Ms. Harrison, but today we're here for 2 young girls, Carol and Sandy. Ms. Pastis' report makes clear that Sissy is not currently an effective and loving mother, that she needs to learn to become an effective and loving mother, perhaps under the mentorship of Carol and Sandy's paternal grandmother. The guardian ad litem was appointed by this court to determine the best interest of Carol and Sandy. It is her belief that Sissy is currently unfit to care for the twins. At this point, Sissy cannot even support or care for herself, let alone care for 2 infants. These investigations support the position of the department that Ms. Harrison is currently unfit and that custody of Carol and Sandy should remain with the department. The department also seeks the termination of Ms. Harrison's consent to adoption. The proposed plan would allow for the twins' paternal grandmother, Mrs. Jackson, to adopt the twins. The guardian ad litem is in support of this plan as it is in the best interest of the twins. Mrs. Jackson is able to currently provide a caring and loving environment as well as proper care and support for the twins. Mrs. Jackson is willing to allow for continued visitation of Ms. Harrison and the twins, while giving Mrs. Harrison an opportunity to get her life together and to finish her education. Adoption of the twins by Mrs. Jackson will also allow for the twins to have a relationship with their father, Robert Jackson. Ms. Harrison certainly has been through some terrible events in her childhood. From this, Ms. Harrison suffers from deficiencies in her education, her ability to adapt to changes, her ability to stay on course with service plans, and ultimately her ability to care for her twins. This condition is reasonably likely to continue for a prolonged or indeterminate period, if it ever changes, leaving Carol and Sandy without the proper care and protection needed from their mother, and in need of adoption by a loving, caring family that in this case is their biological family, who are able to provide a stable environment in which they may thrive. Thank you.
Thank you. That concludes the trial. Now, I asked you all to switch gears and think as the judge right now. Right? What is the first issue on your mind? The first question, or sort of overall question, that you have to ask yourself at the conclusion of a trial like this.
Is Sissy unfit?
Okay, so fitness, all right. And so let's try to think just sort of like in terms of, sort of a bulleted list for our purposes of the positives that we heard throughout the trial, and then the negatives that would contribute to her unfitness. So let's just go around, and starting with Amanda, we'll just go around the room, and Amanda, give us one positive and one negative. Something that you heard at trial that would contribute to deciding the issue in her favor or not in her favor, but a fact.
She has taken parenting classes.
She's taken parenting classes. I'll actually jot them down while you. And how about a negative too, Amanda?
She doesn't have a job.
No job. Okay, Amanda, us?
I would say for one of the positives, attending the visitations with the 2 children.
Attending visitation. We'll say regularly?
Yeah.
You want me to say regularly? Okay.
And one of the negatives would be not attending school, missing school all the time.
Okay. Jim?
Say for the positive, that she still has, appears to have a caring relationship with her grandmother.
Okay. Relation with grandma.
negative would be her, nice way, her poor decision-making concerning her relationships with men.
Poor judgment.
Poor judgment. That would be good.
Regarding relationships. Cole?
Well, let's see. I feel she's been, well, as a negative.
That's
she's-
okay, you can start there first.
Okay, I feel she's been through a lot of violence, a sense of abandonment. There's really no stability in her life,
No.
so I don't know how she would be able to provide stability for her children.
Right?
And a positive outlook, I mean, she's always been motivated to get things done. She's never just sat back and said, oh, this is a bad situation, so what am I going to do about it? She's always done her best and put her best foot forward to do what she needs to do.
Okay. Laura?
On the positives, she raised her younger sisters and showed that she can not only nurture, but she can attach and form relationships.
Your sisters. And negative?
That when she's not motivated, she doesn't perform at all.
Doesn't perform unless motivated, is that?
Yeah, thank you, yeah.
John?
Her truancy, her truancy was reduced out of love for her grandmother when faced losing her.
Went to school when living with grandma.
Yep.
For the most part, because we know she didn't always.
Mhm.
Okay.
She showed a lack of initiative when her kids were taken from her. As far as the transport issue goes, she could have looked for more ways to continue the classes, I guess.
Classes. Okay. Stephanie?
She is able to function in a structured environment, more structured environment.
Okay.
And negative would be her emotional instability through being separated from individuals who she loved, or it could be the emotional instability. She falls apart
Okay.
when things are not structured and stable.
Okay. Mike?
She kind of struggling for a positive now.
Yeah,
I think they're all on the list. I guess just the fact that she hasn't completely given up. I mean, based on what she has gone through and being a 16-year-old kid, the fact that she didn't just throw in the towel, it shows some sort of, initiative, and that I think most kids in her situation would have just said, you take them and deal with them. And then as far as on the negative side, I would say she lacks the coping skills to deal with changes. She's very unable to deal with things if they don't go the way that they need to, or
Okay. Jonathan?
Let's start with the negative.
Okay.
I'll say her age, but not just her age, but just the lack of experience. I think is a contributing factor. And as far as the positives are concerned, I think that she has a lot of potential because if it was not for a lot of the traumatic experiences that she has, she's shown that she has that mothering or kind of like that mother hen mentality as far as her sisters are concerned, and she's continued to show that with her own kids. So.
Okay. Jennifer?
For the positive, I would say her willingness to learn and not give up. I noticed that every time she gets knocked down, even though she stays down for a period of time, she gets up and she at least tries to attempt to make an effort. But that kind of goes into my negative. Sometimes, just because you don't know where to go doesn't mean you should just kind of sit there, you know. She doesn't take initiative to the point where she's asking around, like with the school situation. She didn't try to find the school in the area, which obviously was.
That's similar to this, right? Lack of initiative. Talk about it some more. Let me just see if you're saying something different.
How would you say? I would just say, I was trying to say her lack of initiative to even really do much. She didn't go to school. She didn't try to take the class. Trying to think of something.
What's her situation right now? Amanda, who went first, said no job. Is there anything else we could add to that? Anybody?
She's essentially homeless,
Okay.
sort of.
No.
So no job, no home, really, right? No skills.
I mean, it sort of
Anybody, anything else
touches
that we
on-
haven't touched
well, I
on?
mean, it kind
Think of
just-
facts.
It's little
that-
bits and pieces of all of those
Yeah,
negatives
exactly.
that are in there, but
Exactly.
just the overall experience of what she went through is a negative. I mean, it just, you know, the patterns of abuse that she's experienced, and it's just all of it.
Which is in
It's
turn.
not her fault, but it's still a
Yeah,
negative.
which is kind of the crux of this case too. It's not her fault, but does it somehow contribute to her unfitness? Put fitness over here. And as you guys said at your opening and closing arguments, you know, standard of proof, clear and convincing evidence of current parental unfitness. But in terms of current, we also heard about, you know, we've heard her whole story that possibly the past could contribute in some ways to her current fitness. So if you guys as judges are going to find that the department met its burden, you know, you're going to have to write findings of fact. So that's why I'm trying to get you to, you know, sort of, you know, what are the itemized findings that would support the adjudication of Carol and Sandy being in need of care, because that's the adjudication, just like a defendant is found guilty, right? So Carol and Sandy would be found by the trial court, if the department meet its burden, to be adjudicated in need of care and protection, because the mother, Sissy, at trial, it was currently unfit, again, by clear and convincing evidence. And again, the judge would have to list in detail what his or her findings were that either contributed to unfitness or fitness if the judge ruled, you know, against DCF. I saw a hand up, and I don't know if it was Stephanie's while I was talking.
Yeah, I just wanted to find out, in this particular case related to unfitness, just because she had all these things, you know, as far as in her past, the trauma that has happened in her past,
Right.
doesn't necessarily mean that she has to respond as she has been responding. So, in other words, because if a person goes through tragedies, childhood abuse, and even neglect for that matter, it doesn't necessarily mean that it has to transfer into their current life.
Correct.
But because it has,
Mm-hmm.
that makes her unstable to the point where she's not able to parent as a normal parent would be able to. Because we all go through something, but if it interrupts our ability to do our duty or due diligence related to our children, then at that point we become unfit. Not that unfit would be a negative word per se, but she's not able.
She's not able.
she's not able, and it doesn't make her a bad person, but given her circumstances, she was not able to overcome. So I was just wondering, is that something a judge would think about, or is that up to the person who's defending her to think about?
Right, and add to that too, that none of these in and of themselves is enough to contribute to rule that a mother or a father is currently unfit toward his or her child. They're all factors. They're all factors. And it goes to the relationship of the mother or the father to the child, and whether these facts, because the judge would actually have to point to the evidence, right, that he or she just heard, and make findings of fact. There's going to be rulings of law as well, because the findings of fact then will translate to rulings of law. So these findings, if the negative facts that you guys just said amount to clear and convincing evidence of unfitness, then you also have to write in your decision not only your fact findings, but your rulings of law. What do those translate to in terms of the parent's readiness, willingness, capacity, etc., to take custody? And so remember, if this is a care and protection case, and we'll get to the second piece of this in a minute, that also turned out to be an adoption case as well, because the department had changed its goal. So in terms of the trial, the adjudication is in need of care and protection, but the judge has to go further than that here, because the issue that was also presented at trial was whether mom's consent to adoption should be dispensed with. So then we're dealing not just with fitness, but with what else, Amanda?
Fitness and
So what's the standard for the 210 piece of it?
the best interests of the child?
Yep.
So, yeah,
So now we're
so-
also dealing with the best interest of the child standard as well. And then we look at 210 section 3 and the factors in 210.3 that could amount to a judge making a decision that, you know what, I'm adjudicating in need of care and protection, but I'm going to go to the worst case dispositional alternative under 119.26, and that's essentially termination of parental rights, the dispensing with the parental consent to adoption. So again, think of yourselves as judges, and what facts or factors, whether there's some of these, would cause you, right, to make your decision, again, the worst alternative here, Mike.
I mean, I think just taking out my role in this
Yes, I'm
scenario,
asking you to think as judges
I think it
now.
was a stretch, but I did try to throw it in my closing. Was the factor I focused on was a condition which is reasonably likely to continue for a prolonged, indeterminate period, such as alcohol or drug addiction, mental deficiency or mental illness, and the condition makes the parent or other person named in Section 2 unlikely to provide minimally acceptable care for the child. So, I mean, I tried to focus on that. That was the only real factor that I thought
I wonder if I can do this. I probably can't fit much, but
really shown in the facts, and was basically that,
condition that won't change, you're saying, basically.
yeah, it's not
one of those
reasonably
factors.
likely to continue for a long time
Mhm.
or never change.
Okay. So a factor that would rule against her in terms of
Right.
adoption.
Otherwise, I really,
Mhm.
you know, there were other things that, you know, if the child was abandoned, but none of that was in this
Mhm.
case.
Anybody else have any other thoughts? You going to do away, Laura, with her consent to adoption? You can terminate her parental rights as a judge?
I wouldn't, and there doesn't mean that.
Think of the cases that you've read as well, and on
Right.
top of these factors.
The reason is, it doesn't mean I'd give her the children tomorrow, but I didn't think, I thought that the service plan, her and the service plan could eliminate like the majority of the concerns on the right-hand side. On
The negative concerns.
Yeah. So I wasn't ready to go so far as to adopt the children out. I didn't think she had an opportunity. I also didn't think that, I mean, she could have been living at her grandmother's house with the children, and while she didn't have a job, you know, it's possible her grandmother was paying.
You said something in your closing, and you used the term preventive.
Yeah.
Why not be preventive in the sense that the legislature's goal is, yes, to try through these statutes and, the agency's work to keep families together, but also to recognize that there are times when the state should and could and will intervene in family life, and in terms of the best interest of children whose parents are likely, Mike said a condition, are likely to be unfit for years, is to maybe free them up for adoption, especially when they're so young, before trauma could occur. Do you know what I'm saying?
Yeah.
Go ahead.
Yeah, we actually did one case, but I thought that was distinguished from this in that I think that was the French family, and they had like 4 children, and they had found that there was trauma to the oldest 3, but not the 4th, and the judge said, I don't need to sit here and watch you
Wait for disaster to happen was
Yes.
the quote, yeah.
Yeah, and I thought that was distinguished from this case in that she had a service plan that she hadn't had the opportunity to put into place, and that everything was covered in that service plan, and that she had also shown that when she's motivated, she could be very acceptable, and I thought it was too early. And also, the 2 factors for terminating adoption are parental unfitness and the best interests of the children, and that I hadn't felt that we really proved she was unfit.
So you would concede as mother's counsel that, yeah, she might be, unfit right now to have custody, but it's premature to terminate her parental rights?
That was what I believed.
And Mike, you had your hand up too.
Well, actually, we talked about this before class.
Okay.
I agree, just from my own personal stance, is that she is, I feel, currently unfit to provide care for the children, but I don't think she did get that opportunity to really try to make things better. I mean, essentially, the kids were taken right after they were born, and I think before they're going to dispense with her consent to adoption, she needs to be given a chance to try. There were enough of the positive things of caring for her sisters and glimpses of initiative that she should be given that chance before that right is taken away of her, being able to eventually be the parent of her children. It's sort of a balance of the best interest of the kids, but also her right to be a parent. And I didn't feel like this case, there was enough on the negative side to say you're never going to be able to undo your life. There's a chance. She's a 16-year-old kid, and there have been glimpses of initiative and improvement, and the kids are relatively young. They're only like a year old, and so I think having them in the care of the department while mom has a chance to get her life together over the next year or so would be appropriate.
So you just said you're a 16-year-old kid, and Jonathan had actually listed age, lack of experience in one of the negative facts about Sissy. So the fact that she is a kid, does that make her unfit? Or, well, could that be a huge fact? We said before, no one fact, that the judge should or could, Jonathan, rely on to find her unfit?
I don't think so. I think that the age is a factor. I think if anything it would be maybe a magnifying glass, if you will, for any of the other factors. Just given her age and her struggles, maybe that's something that they could take into account. But as far as the age itself being the reason or the catalyst for finding her unfit, I don't think that would be proper.
And Nicole, you had your hand up too?
I don't feel that just because you're a teenager and you get pregnant that you're automatically seen as this person who can't take care of your children.
You can't.
Yeah,
Yep.
I mean, there are so many people who get pregnant when they're teenagers and they still raise their children. And if anything, the court should see them and give them more respect because they're giving up their life to raise their children. They didn't, do away with the children during, pregnancy, and they didn't, they really do, a lot of them do try their best to provide for their children, and as long as they have a strong support system for their families, or if they have, the father.
But here's the thing, she really didn't. Then that was the scary part about her case. So the grandma was actually a great grandmother. It doesn't say how old she was, but she was, she was elderly and she had the health issues and all of that. So when you say, she does well when she's in structured environment, she should have support and whatnot. She would have to be she would really have to get her act together to get these kids back. And in the meantime, they're getting older, they're forming bonds, when we have a scenario like the Linus case that the attorneys had talked to you about.
I tried to point that out in my closing, was that, being a teen parent is difficult. Being a teen parent to twins is even worse. And then you throw all of this on top of it, it's almost impossible. I mean, she really does have an uphill battle to fight. But I think, just in fairness, I think she should at least be given the shot to try. And I don't think that happened here. I mean, essentially, my understanding was, they took the kids right away, and she hasn't had any chance to show it. So, because the kids are, relatively young, they're less than a year old, if they're in the care of the department over the next year, let her have a chance to try to, maybe, go to school, get her GED, get a job, show that, look, I can do this.
And
then
in
if
the
she
meantime,
can't,
yeah.
then
And
if
in
she
the meantime,
can't,
the
then you take away the
right.
the
The
right to go.
DCF is going to be holding, within the agency, the foster care reviews. The court also holds the 29B annual reviews. She also has the opportunity under Section 26 to come before the court even before that on a review and redetermination. But none of that happens if her parental rights were terminated. And then her only recourse would have been appeal on some kind of error of law. Laura?
I also felt that there's some balance of equity, like as the state, we put her through incredible trauma.
Right.
And
right.
we separated her by 30 miles from those babies.
Right.
And it was once a month supervised visits. I mean, that's horrific, I think. And I thought that just, in balancing the equities, like her last suicidal thoughts were when these children, she, endured the loss of her sisters and everything, and that just in fairness, she needed an opportunity. The second thing was, I get a little concerned about and it goes back to that case we watched online, but we didn't have a chance to discuss, was the adoptable children. Two beautiful, those two little sisters, they were two beautiful little girls, and they were of the right ages to be adopted.
Right.
And one of the things you said like a moment ago, these are very adoptable babies, and they're twins, and
right.
like that concerns me that we jumped the gun. We could be reading about her being, some fabulous attorney 20 years from now, and that that this is
Right, and we have to be careful when we say best interest of the child. You're not taking the child by himself or herself or themselves in a vacuum. It has to do, again, with the relationship with the parent. It's not whether the child will be better off in that beautiful, White House with the pillars
exactly.
and the dogs and all of that. It has to do with the Supreme Judicial Court has said that the fitness test and the best interest test are not, quote, separate and distinct, but cognate and connected. You always have to take them together. So I think, and it seems like we're all in agreement that, well, she's not ready right now, so the children would need to be, at least for now, adjudicated in need of care and protection. So, and that means DCF, as you just said, gets custody. DCF will go forward with service plans. She still maintains her parental rights, visitation, can come before the court for any abuse of discretion that DCF allegedly, commits, etc. The reviews in court, DCF as well, so she maintains all of those rights. Of course, she has lost custody. That means, again, under the definition of custody, Section 21, DCF can control, the place of abode, the visitation, can enlist contracts, etc., but all in the name of following properly their own rules and regulations, following the law. And the court, similar to some of the adoption cases that you read, the court is reluctant, would be reluctant, and would probably say in his or her findings and rulings that it is premature to what's that noise to terminate her parental rights. Any questions? Because now we're actually switching to the next piece of the course,
So,
the CRAs, formerly called CHIN. So any questions at all on camp protection? Yeah.
this was a real case, right?
Yes, it was, and you got a little piece of it, which happened to be one of the reports. If you ask me about the father, I don't know. I don't know where he was. I don't know if he was actually living with his mom. Some of you brought up that question.
Do you know what happened in how it ended?
No, I'm sorry, I don't. I know how it began and what was going on then. It was long ago. Yes.
I have a question. So, one thing I didn't understand from this fact pattern from the report was, if DCF was moving for the children to be adopted by the paternal grandmother, why weren't they placed with her?
Yeah.
Why were they in foster care?
Yeah.
didn't
I think
understand
at
that.
some point that they were.
Okay, it just didn't make sense to me,
yeah.
that if you're trying to say, oh, this person should adopt the kids.
And
why
again,
wouldn't they
whether
be-
it originally had something to do with the bio dad.
Yeah,
Yeah.
it just
So
didn't make
that's-
sense
yeah.
to me.
Mhm.
Because you would think you'd want to foster that relationship as soon as possible, if that's
Right.
what your,
Exactly.
that's what your goal
Exactly.
is.
And obviously, he would have had notice of the proceedings, would have had counsel himself. That would have been another piece of it. And whether, even if he was, had issues like she did, DCF's obligation to place with family would have meant that, maybe they would have been placed with grandmother, maybe even from the beginning. But we didn't have that piece of it, so.
Yeah, it just didn't make sense.
So let's just start with some of the cases that you had to read. I think Brasher was the first one. And let me just say a little bit. You're going to hear from Mike Kilkelly on Tuesday. Mike is a phenomenal attorney who has been in this field for a long time. And he was the attorney responsible for setting the standard in the Roberts case, Wonders of the Evidence, but he also has been instrumental in Chin's legislation and Chin's cases. Two of the cases that you're reading, Hillary and Angela, that really set precedent with regard. I'm going to be saying Chin's interchangeably with CRA. CRA is the newer version. So excuse me, it's just like I keep saying DSS instead of DCF. So he'll speak to you more in length about the statute. But let me just say, at the beginning, the first two cases that you had to read are really old cases. And notice they were Commonwealth v. Brasher, Commonwealth v. Johnson. So the Chin statute itself was really not that old. It was an attempt by the legislature to decriminalize certain acts of juveniles. They really are not criminal offenses. The acts themselves for which a juvenile could be within the jurisdiction of the juvenile court and are still part of the newest CRA legislation are acts that are not crimes. So running away from home, there's four of them, and actually there's a fifth with CRA that has to do with sexual exploitation. But the first four have been around for the longest time. Running away, disobeying the rules of the home, what we used to call the stubborn child, being truant, and so the next two are school offenses. Being truant is the third, and then the fourth is disobeying the lawful and reasonable regulations of the school offenders. So the first case is Brasher. Has anybody read that and want to tell us a little, Nicole?
Well, on May 3rd, 1969, a complaint was filed alleging that the defendant, child, which is between the ages of 7 and 17, but didn't you say now it's 18?
Yes.
Okay. Well, they were a delinquent child because she was considered stubborn. July 12th, 1969, the child was sent to BYS custody. The defendant argued in Chapter 272, Section 53, that the stubborn child, it was too vague and indefinite. It left judges and jurors free to decide without any kind of like legal standards as to whether or not this kid was delinquent or not, and so it violated the child's due
What did
process.
she do? Do you remember?
I don't remember. I didn't write.
Where was she living? Because it was, the complaint was from this group home or whatever it was called, right?
Yeah. Oh, she was supposed to see a doctor. She refused. She got mad, so she slammed doors and screamed, even when the mother of the home asked her not to. She was placed in what was called a Group 4, which is like a non-privileged group. She ran away from the home when she knew she wasn't supposed to. She had outbursts, and she wouldn't respond to the house mother trying to tell her to stop. So they ruled that she was in need of services. So I would agree. They said that the elements in which the Commonwealth was required to prove was it was beyond a reasonable doubt that the stubborn child was a person having authority to give a child under the age of 18 laws and reasonable commands that a child is bound to obey. That's what they're allowed to do. And then the second one was that the child refused to submit to the commands, and the refusal, which is considered stubborn in the sense it was willful, obstinate, and persistent for a period of time. So that's what the child would have to be doing in order to be labeled as stubborn, which is such a weird thing. Like stubborn, I mean, why is that so? I don't really understand why that's so bad.
And even though this case is that old, the elements are pretty much what you just mentioned. The elements are pretty much the same, that you're given by, your parent, lawful and reasonable commands, as the case says. You refuse to submit in a willful way over a period of time, not single. So if there's a CHINS application or a CRA application that's, as this case says, single, infrequent, isolated, it doesn't amount to enough for the court to accept the application. What I love is because I didn't know if you had the case in front of you, that she used, I guess, quote, vile and vulgar language, formerly used only by, I think it was sailors or something that engaged in gutter brawls. So that was what the activity she engaged in that, amounted to, and what's the standard of proof?
A reasonable doubt.
Yeah, and that has stayed with the CHINS and now the CRA statute as well. So it's weird because, we moved from care and protection, which is a case about children. Now we still have a case about children. It's not the Commonwealth, even though these older cases were the Commonwealth. That was before the legislation had actually been passed that decriminalized those cases. So if you caption these cases today, they're, like an in-ray sort of, in-ray polycaldis or, CRA application of polycaldis, that sort of thing. So there's no plaintiff and defendant in that sense. And yet, the standard of proof for the care and protection cases is clear and convincing evidence, which is not a criminal standard of proof. So now you have in these cases, and it has stayed from the older cases where they were actually prosecuted. But the legislation that decriminalized these acts did not get rid of the criminal standard of proof. In fact, in Massachusetts, we used to have what was called a de novo system, where a criminal defendant could go to trial in the district court, go through the trial, be found guilty, appeal, but the appeal wasn't to an appellate court, the appeal was to a jury session of the district court. It was called a de novo review, which means brand new. In essence, the defendant got a brand new trial. Well, the CHINS statute had, up until the latest change, the CRA change, the Chin statute had actually kept the de novo review as well for juveniles engaged in the Chin's process. So if anything, the Commonwealth v. Brasher case might still be cited today sort of for the definition of a child who refuses to obey his or her parent's command, and that the parent is filing an application in the juvenile court, asking the juvenile court to, help that family. And in fact, the new legislation talks about and defines not only the child requiring assistance, but the family requiring assistance. Whereas the legislation before that was just about the child himself. It was child in need of services. So if anything, that's the only thing you should really take away from the Brasher case. So that was the stubborn child. Now Johnson is a school case. Anybody want to do the Johnson case? Mike, all right.
So, let me just get some of these here. This was a case against 3 kids. They were all under the age of 16. I think they were 12, 11, and 7. And essentially, they were suspended from school for refusing to do the Pledge of Allegiance. And they refused to do it because they're a Jehovah's Witness. And the school had made some requirement that all students had to recite the pledge. And otherwise, the kids are well behaved in school and did well in school. And so essentially, they were suspended from October until February. And the school committee filed for a chins, saying that they were in need of care and protection. That they were a child in need of services, and the judge found them in need of services, and then they refused. I think he was going to suspend their sentence, or they refused to do it because they were appealing that it was illegal for them to be required to do the Pledge of Allegiance. And so on appeal, the Supreme Court determined that it was unlawful for the school to require them to do the pledge. I think it had to do with it because it wasn't a public school, it was a private school. And so because it was illegal, the ruling of child in need of services against them was dispensed.
Well, that was before Chin. There was no such animal as Chins back then. That was the case was decided in 1941.
Okay.
So instead, again, both Brasher and Johnson at the time were criminal cases, and criminal cases that, again, predated the Chin statute. But the acts that the juveniles had committed were not crimes, and therefore later on the legislature enacts Chins to try to decriminalize these acts that were, again, not criminal, but that merited, the courts, the schools, the families from trying sort of to help kids before they then started engaging, in actual crime. So that was the reason for the Chin statute. And the children in this case, in Johnson, were alleged to be, school offenders again, and that's still one of the elements of a current CRA case. A child that repeatedly, willfully refuses to obey the lawful and reasonable regulations of school. And so that was the issue back then before the SJC. So for that, again, for that holding, the case is still good. So now we have a couple of cases that deal with the authority of the juvenile court, the School Committee of Worcester, and then the Oscar case. I'm going to skip over Gail. In fact, I had been thinking of, and for some reason did not delete it from the CD, because actually the Angela and Hillary cases, and when we get to Angela and Hillary, we'll talk about it, pretty much overruled Gail, because the SJC recognizes parental liberty in these cases. But let's talk about school committee of Worcester. Amanda.
So this was a situation where a 9th grade student brought a knife to school with her when the school had a policy of bringing no weapons on the premises. And if they were to bring a weapon to school, then they were to be suspended or expelled for a term of 12 months. The juvenile court issued dispositional order to the Chins proceeding order and that the juvenile was to continue.
So wait, stop for a second. So how was it, who brought the Chins proceeding? And
The
what-
school. I think
Okay.
it was the school that did.
Mm-hmm.
Let me just go back. The school. The
The
court
case that goes,
determined
I'm
that,
sorry, go ahead.
the court determined that the juvenile was in need of services and held a dispositional hearing as part of the Chins proceeding in December of 1990.
What else did the juvenile court do? And that's the reason, which became the reason for this appeal.
Question about the details in the policy that the school had.
Yeah, you just said that the court reinstated the juvenile, right?
Yeah.
What else did the juvenile court do as
Um,
part of the disposition?
Overturn the expulsion.
They did do that. Nicole, did you want to add to that? It
The
was,
school committee and superintendent, they weren't technically parties to the case, so they filed a complaint seeking a stay of the order, and the juvenile court
oh,
granted.
what? Okay, go ahead. I think you're going to say it. I'm sorry.
The juvenile court granted it and allowed the child to go, to not be brought back into school because they didn't.
Because
Right.
why? What did the court say about the school policy? Because remember that when we just talked about Chins with Brasher and with Johnson, the elements of the Chins for school offender has to be a violation of the lawful and reasonable regulation of the school, right?
Yeah, I
But-
think the case also said that the school wasn't exactly prohibiting education, it was just prohibiting education in Worcester because that's where the offense took place.
Okay, but what did the judge do that was wrong?
Acted beyond his authority.
Yeah, that's what I was trying to get at. Acted beyond, meaning what? Acted beyond, because you're going to see that a lot, the authority of the juvenile court. So this is kind of similar issue-wise when we looked at the C&Ps and the abuse of discretion, where the juvenile court couldn't interfere, unless DCF was was violating its own rules and policies. So in this case, similar, I said, again, legal issue-wise, the court goes beyond its authority. Why and how?
By making the kid go back to school?
When he
That's
found that the school,
policy.
But what about the school
that it
policy?
was unconstitutional.
Yeah. Yeah, the
in
juvenile
order to
court
reinstate it.
didn't have the authority, and the SJC says either express or even imply, to determine the constitutionality of the school policy. So say you're a litigant or a party that does think that there's something unconstitutional. So you look at the handbook, right, and you think that there's something unconstitutional, right? What do you do?
You're the judge?
It's not a chance.
No, you're a party. You represent the kid, or you're a parent, or Say, wait a minute. He shouldn't have been expelled. The school policy's vague, or there's something wrong with it. In terms of due process or whatever your issue might be.
You must have to file a separate motion that they're violating your client's due process.
A separate what? Not motion.
Complaint
Where?
in the district court.
Put
Or in the juvenile
federal
court.
before that and you'll be right, right?
Federal.
A civil rights proceeding, probably, might, something like that. Juvenile courts, they don't have that broad, yes, there's the equity power of the court, but if the court goes beyond what it's supposed to do in a chins proceeding. And you see that, notice that you've just really got a handful of chins cases. They don't get appealed. People don't know what to do with them. As Attorney Gargano said, they're for the most part. They've progressed a lot in terms of due process rights and rights of parents and children from the beginning, but they're weird kinds of cases. Petitioners, who's the petitioner in a chins or CRA case? So for example, in the CMP cases that we just finished, for the most part, the Department of Children and Families is the petitioner in 99% or more of care and protections and 210s in the Commonwealth. But if a child, again, runs away, doesn't obey at home, is truant at school, doesn't obey at school, who is the petitioner?
Parent?
Yeah, either parent or
Could be the
school.
parent or school.
Yeah, yeah, and it used to be in chins, the police could petition in the old runaway cases. In the new legislation, I believe it's just parents or and the thing about parents or school, and school official is usually like not the resource officer. Who am I thinking of?
Guidance counselor?
Probation officer?
Who's the truant guy? What do they call him?
Truant officer.
There's some term. Anyway, school officials for the most part. The parent typically would just go to the court, and that's done today. And there's more of a process with helping families today, and Mike will tell you more about it on Tuesday. But when the department filed the CNPs, you had an attorney, right? Right after, yes, it might be an emergency hearing where the social worker, starts it off. But then you have an attorney running with the case, filing motions, doing what he or she has to do legally, right? To satisfy the standard of proof. A parent can't do that. And the school official that's really filing for truancy or disobeying it's not the attorney for the town that gets involved, unless in some rare cases. So they will read cases in terms of, well, you have this criminal burden of proof beyond a reasonable doubt to adjudicate a child at chins or CRA today. But you really have no lawyer conducting and trying to satisfy that standard of proof. So, that's one piece of these cases that's really very difficult in terms of having the court involved. And that's why with the latest developments by the legislature, the new CRA, it does leave more room for probation officer to conduct in the best interest of the child what kind of services the family should get. They try as much as possible to keep them out of the court system, and that's why they're called CRAs, child requiring assistance, family requiring assistance. What kind of services can we give in the best interest of the child before the child has some sort of because it's still a record even though the child hasn't committed a crime. So that's my little thing. Let's get back to the cases. We'll talk more about this. Let's do the Worcester case, the Oscar v. County of Worcester. Laura?
So in this case, the truant officer for the Leicester Public Schools brought the chins proceeding. And it was about a boy who was not attending school. He was 13 years old and living with his mother. So a very similar case to the one we just did, and the juvenile court judge adjudicated that Oscar should be enrolled in the landmark school in Beverly. He attended for a few months, and the treasurer of Worcester County declined to pay the expenses for the school. And so the holding was that the judge had gone beyond his authority, that the judge may refer a child who is the subject of a chins petition to the appropriate school committee for determination of whether the child receives special ed. However, the judge cannot make such a determination and order a particular special ed placement.
Okay. Another case involving the authority of the court. So yes, the court, as part of Chins, would be concerned with the child getting education, proper education, making sure the child goes to school, etc., which might be conditions relative to, having him released back to his parents' custody, but the judge has to be careful not to issue direct orders, and that goes to both the Vincent and the Florence cases. And those were straight Chins cases, one in 1990 and one in 1999, that both dealt with, again, direct orders of the juvenile court judges. Let's see, Jennifer?
Which case?
I'm sorry, what did I say, Vincent? What did the kid do in Vincent that subjected him to a Chins petition? Jonathan?
He was shorn from school.
Okay.
And he wouldn't, he was involved with the juvenile court, and the judge required him to go to school under court order, and he neglected to do that, so the judge wanted to find him in contempt for not obeying the court order.
In contempt?
Yeah.
Are you reading from the Florence case or the Vincent case? I just
Vincent.
want to make sure. Okay.
Right?
Yeah, go ahead.
Yeah, they said that, I believe he was 13, I think,
Mm-hmm.
13 years old, and they said that he just was a smart kid, but he just would stay up late and would sleep during school hours. So that was the reasoning behind him not obeying the court order.
So what should the judge have done? In what way should the judge have fashioned, the adjudication of Chins and then the disposition to the kid that would not have gone beyond his authority? What would have been the right way to do it?
Send him to DYS?
No, be careful now. I'm glad you brought that up. When we get to the delinquencies and the youthful offender cases, the agency that's involved with those kids is DYS. The agency that's involved, if at all, with Chins and CRAs is what? Not DYS, but DCF. Because again, the kids have not committed crimes.
But if,
Go ahead.
sorry if I'm
Yeah,
not understanding this,
yeah.
but I thought what the case was getting at was that if he was going to be held in contempt of court, then that would be considered a crime for a youthful offender.
Well, that's what the judge was trying to do, right? What was the judge trying to do?
Trying to, send him to DYS.
Yeah, and you can't criminalize a Chins case.
Okay. 'Cause it
Right.
was initially
And-
a chin.
And what you want to do, if you do it right, you're going to adjudicate the kid a Chins, and you're going to say, okay, I'm going to let you go back home. So custody to mom and dad. A condition of custody is that you go to school. And that's the sad thing about it. You go to school, there might be other things, right, that are conditions of custody. But if the kid doesn't do it, if it's just a straight Chins, straight CRA, they're not criminal cases. So the judge has no authority beyond just bringing them in again, trying to deal with what services, etc. And it had, in fact, been called, and I don't know if it's still called this way as a CRA, the statute with no teeth. Because and therefore you have some of these cases that went up on appeal because the judges tried to have some teeth, tried to
Give him some consequence.
exactly.
Right.
But it would be on the authority of the court to do so. Yeah.
So what happens if the child is brought back in and they haven't complied with the court?
Okay. So say the child, the judge had issued an order that said custody to mom and dad, need to go to school, you need to have a curfew, need to, not get any more detentions, whatever, right? And as you said, he's brought back in, okay? What might then be the next step? Remember, it was conditioned, the condition was custody to parents.
Then he would go to DYS.
Not DYS,
DCF.
DCF. And it's then, and let's skip over Florence because it's pretty much the same holding. What is Hillary, and I'm going to jump to Hillary, I think you guys had Angel on next. Because if the question then becomes, so Jennifer, in your scenario, the kid is coming in, everybody knows that he hasn't complied, right? Parents know it, kid knows it, kid's attorney knows it, probation knows it, school knows it, right? And everyone pretty much knows that he probably, that either the court's going to be asking or DCF's going to be asking for custody, right? What does that then mean in terms of parental rights? So Hillary was decided in 2008. Before 2008, who were the parties in Chin's case? The only party was the child. The child got counsel pursuant to the statute. And again, the criminal standard of proof. The only attorney in the courtroom back then was child's counsel. So Mike Kilkelly said, hold on. What parental rights are then at stake if it looks like DCF is going to get custody? And it's similar to the C&P stuff that we just discussed, right? Laura?
Parents.
What's it?
Parents' rights.
Parents' rights to custody of their children, right? And it goes back to the early cases you read. But before then, parents did not get lawyers in Chin's cases because the case involved, an act that the kid had done. And the kid's liberty was at stake. And so Mike raised the issue to the SJC and won that, if it comes to the point that the parent's going to lose custody in a Chin's case, then parents should get counsel. And that was and is the Hillary case. The SJC in Hillary agreeing with them that was a substantial intrusion in the parent-child relationship, the parents' due process, the 14th Amendment rights, all that stuff we talked about early on applied. And also some of the other portions of the C&P statute that you guys have looked at already also apply in these cases, because when DCF is involved, now you've got an agency also with service plans. Also, DCF getting custody means there's going to be annual reviews, just like in the C&Ps, the annual permanency reviews under 29B. The 29C findings, 29C being that reasonable efforts requirement that we talked about, that DCF shouldn't be getting custody unless DCF has shown some kind of reasonable efforts to work with the family, blah, blah. So all of that stuff applies to Chin's cases, /CRA cases as well.
But only after...
When DCF gets custody.
Right.
Yeah, so you might have just a straight, say, truancy case. That's the school and the parent, and that's sort of taken care of. Parent never really loses custody. They deal with the issues of the kid being truant, for whatever that reason is. I'm not going to get to Angela because we're going to run out of time, but I just want to say, you also want to think about when you get a fact pattern of a kid that has engaged in any of these actions. Notice I'm not saying offenses because they're not criminal, but you want to think of the reasons for which the kid has done it. And in some cases, they're really parent protection cases. They're really cases where there's been abuse and neglect at home, and that's why the kid is running away, or is truant and not obeying, etc. So some of these cases absolutely do overlap. If, for whatever reason, if Mike gets stuck in court, doesn't show up, we'll go on with the rest of the cases and the hypothetical that I gave you. If not, plan for it. He'll probably take, a half hour to speak to you and then questions as well. So read through, the CRA statute and the cases.
The cases like the student suspension.
Yeah, try to do the
violence.
rest of the reading through next week for Tuesday, just in case he doesn't show up. If he shows up, then obviously we'll finish it on Thursday. Thank you.